before the court is file 23110FC. It's People of the State of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark?
Yes.
All right, Mr. Vander Ark, Ms. Vander Ark, can you hear and understand me okay?
Yes, I can.
All right. Ms. Vander Ark, we had confirmed through your counsel that you wish to appear at this hearing via Zoom today. Is that still your desire?
For this hearing.
For this hearing. Okay. All right. Mr. Ambrose is here on behalf of the defendant, Ms. Vander Ark. Mr. Roberts, as well as Ms. Bloomquist, is here on behalf of the people of the state of Michigan. State and time scheduled for a hearing on plaintiff's motion for a new trial or evidentiary hearing. Or excuse me, defendant appellant's motion for a new trial or evidentiary hearing. The court has read the motion, the attached brief, as well as the plaintiff's response and brief in opposition to that evidentiary hearing, including the attachments. Was there anything else that was submitted, either Mr. Ambrose or Ms. Bloomquist, that I don't have at this time?
I have not submitted anything.
Okay, Ms. Bloomquist?
No, Your Honor.
Okay, Mr. Ambrose, at this point in time, you want to just make some argument? You can call witnesses. I'll leave it to you at this point.
If testimony is going to be taken, I would prefer that I have my client with me in person. That's our preference in this type of setting. Typically, on a motion like this, if the court grants any type of evidentiary hearing, that would be great. And then we could have Ms. Vander Ark in person with us.
Okay.
But other than that, I did write a pretty detailed brief in this case, raising two primary issues. One is whether or not Ms. Vander Ark was competent after giving her first day of testimony. She had a medical issue. She was in some sort of distress. Coming back the next day, it seemed pretty, from the transcript at least, that she had undergone a significant downturn in her mental health. That it was described by her trial counsel that she was not competent to go forward. I think there was about a 2-hour delay. There was some sort of discussion with Ms. Vander Ark. There was a report that she may have wanted to hurt herself. All of these factors are pretty consistent with the case that I cited, seminal cases, Droke versus Missouri. And if you look at that case and Ms. Vander Ark's situation, they pretty much fall in line. So, if the bottom line is, well, was there a bona fide doubt as to her competency? And if there was, then the way to go about things is suspend the trial, have her checked out, and then if there is no longer an issue there, then proceed with the trial. And that's consistent with what Droke says, but it wasn't done in this case. And if there is additional testimony taken on this issue alone, like I said, I would like to have Ms. Vander Ark here for that. The second issue, Your Honor, is ineffective assistance of counsel. I laid out a number of areas that I feel that there were some missteps in that Ms. Vander Ark was not provided her Sixth Amendment right to the effective assistance of counsel. And we do start off again with the competency issue of not requesting her to be evaluated. And so that was one issue. Another issue that we raised is Ms. Vander Ark testified at the time of trial. She's always remained consistent about her innocence. And trial counsel, during his closing argument, made a statement to the jury that she was guilty of manslaughter. Well, my client never consented to that type of argument, never consented to a lesser included offense. So that's a second issue that we have raised, and is ineffective assistance of counsel. I've made a number of other areas that we felt that trial counsel was ineffective, and one was on the death certificate. The first thing that is noted is dehydration. And in this case, there was many allegations about Ms. Vander Ark restricting food to her son. But there was never any type of allegation about restrictions of water or liquids or fluids. And if you do any type of research in this area, you know, a person knows that they will die within days if they don't have any type of water. But a person can literally last weeks, sometimes months without food. And so with dehydration as being the first statement in the death certificate, I think it was important to highlight that as a trial counsel, because that is what's the first statement. And I think in my reading of the transcript, there was only one question about that by trial counsel. And I think the main focus in the case could have been or should have been that the real cause of death was dehydration, because there was never any type of restriction on water. But like I said, Your Honor, I have outlined, did a detailed brief in this. I'd be willing to answer any questions that you might have.
All right, real briefly, I just want to make sure that the court understands the argument regarding the competency. The claim is, my understanding based on the brief, is that the competency or the incompetency, alleged incompetency, occurred not during the whole trial, but simply at that moment when she was done with questioning. At the end of the day, I think it was on the 14th. I think it was Thursday. Is that correct?
That is correct.
So there's no allegation that she was incompetent at any other point during the trial except for the moment she was done questioning. The court, I think, was going to break for the day or something like that, correct?
That's the pivotal portion of the case.
Okay.
Because she goes through, and granted, prosecutor did his job. I mean, he was tough on her, and that's his job, and I can appreciate it. But it had a significant impact. Apparently, my understanding is that she was pretty much paralyzed, and couldn't move, and couldn't function the following day.
Okay, all right. That's all the questions I have at this
Thank
point.
you.
So, yep, thank you. Ms. Bloomquist.
Well, it's the people's position, Your Honor, that the defendant's not entitled to a new trial because she was not denied a fair trial on the bases raised in her motion for new trial. Specifically, her issue 1, dealing with competency. The test for this is there's a presumption by statute that a defendant is competent to stand trial, and that is MCL 333.2020 subsection 1. And the test that this court is supposed to apply, or the test that would be applied on an appellate basis of this court's decision not to hold a hearing, is that when facts and circumstances are brought to the court's attention, or that the court itself observes, raises a bona fide doubt as to the defendant's competency. That's when a hearing on a defendant's competency should be held. It's our position that in light of the facts before this court, the facts in the record, and the facts known to all parties involved, that there was not a bona fide doubt as to the defendant's competency. And our appellate courts have set forth certain considerations for a trial court, when it was situated as you were, to make this decision. The court can look to the defendant's irrational behavior, the defendant's demeanor, and prior medical records related to competency. And I guess the main crux of this, and that's People v. Camerad 307 Mich. App. Your Honor, there was never anything in any of those 3 components that are factors for this court's consideration that would support that the defendant was in fact incompetent to undercut that presumption of competency. In fact, I would assert that the record before the court is that this was a feigned bout of incompetence to harbor an appellate parachute to undermine a jury verdict. And I think the court also is well aware that Ms. Vander Ark is a trained individual who might not be an attorney, but she went to law school, and by her own account, she was very smart, passed the bar, has all sorts of knowledge on certain things that she could do to undermine a jury verdict in this case. And People v. Cameron specifically says that if the defendant's actions are purposeful and are more or less a strategic game, it is not an expression of mental illness or a denial of reality, and it would be proper for the court to not find a bona fide doubt as to her competency. So turning to the facts in the record, Your Honor sat here and watched Ms. Vander Ark during the days preceding this alleged incompetency. She was present at counsel table mere feet from Your Honor. She testified before Your Honor. You were able to see her interactions with her counsel, with individuals that were part of her defense team, as well as to hear her testify. Nothing in what happened in the days leading up to this incompetency would support that there was a bona fide doubt as to her ability to be a part of her defense team. Further, I think with that, what's very relevant and highly probative to this question is there was a pleading almost identical to this that was filed on a motion to quash bindover to send this case back to district court, where Ms. Vander Ark alleged that during her preliminary examination she disassociated and she was unable to be present because of this condition at her preliminary examination. She raised these same issues as to competency. The motion to quash was presented to this court, and my understanding from that is that the court was able to review her competency evaluation that was done by the Center for Forensic Psychiatry here in the state of Michigan. And as that report indicates, if the court would bear with me a moment. As that report indicates, the defendant had a, quote, sophisticated understanding of the roles of the various court participants, her defense options and possible outcomes, and clearly voiced her willingness to engage and rationally assist her attorney in this matter. And then the clinician went on to say, I did not observe any behavior indicative of an intellectual disability or other cognitive, physical, or psychiatric issues that would impede her adjudicative competencies. Your Honor, the court can absolutely consider all of that in making this determination as it relates to the defendant's competency, and I think that the record supports that this court made the proper determination that she had not overcome the presumption that she's competent, and in fact, not holding a hearing was the right decision on this matter. Now, to succeed on a motion for new trial, the defendant would have to show that there's a basis for appellate relief. And looking at your decision and this court's decision, there is not a basis for appellate relief on this issue. Now, I do know, I am prepared today to take additional testimony should the court require it on this specific issue in the form of individuals who saw her during this claimed incompetency, who would be here to testify as to their observations of her outside of what the court itself observed in making this decision. And so I'd be prepared to do that today as it relates to issue 1. But ultimately, Your Honor, there is no basis for a new trial as it relates to her feigned or malingering incompetency that's been presented today. Turning to issue 2, as the court's well aware, the burden's on the defendant to prove that she was denied the effective assistance of counsel. And that burden's twofold. First, she has to show that there was deficient performance, and she has to show prejudice. And I'm going to be a little bit out of order here, Your Honor, because she has to prove both. She has to prove both prongs. And in light of the overwhelming evidence that was presented about this defendant's culpability and her guilt in what happened with her son, it's my position that she can never establish that any of these claimed instances of deficient performance, which I don't agree are deficient performance, but for the sake of argument, if we were to assume they were, she could never overcome that second necessary requirement of showing that any of Mr. Johnson's actions prejudiced her in light of the overwhelming evidence supporting her guilt. And I do have all of my responses to the prong 1 as it relates to those, as it relates to the individual claims of deficient performance. But Your Honor, I don't believe that the defendant can ever meet that Strickland standard and show that she was denied the effective assistance of counsel. I would note, however, like I said, for issue 1, I do have Mr. Johnson here, who, as well as another individual from his office, who would be willing and able to testify if the court were to order again their hearing. And I'd be happy to answer any questions the court might have.
All right, no, I don't have any questions at this time.
Thank you.
Mr. Ambrose, I'll give you a chance to briefly respond if you wish to.
I wouldn't say, thank you.
Okay, all right. All right, well, as indicated by both attorneys, the court always starts with a presumption, that's under MCL 330.2020, that a defendant of criminal charge is presumed to be competent to stand trial. That statute indicates he shall be determined incompetent to stand trial only if he is incapable because of his mental condition of understanding the nature and object of the proceedings against him, of assisting in his defense in a rational manner. There is case law that also indicates that, quote, a criminal defendant's mental condition at the time of trial must be such as to assure that he understands the charges against him or her and can knowingly assist in his defense. The court, obviously the parties know under court rule, either the parties or the court sua sponte has the ability to address the defendant's competency at any point in time in the trial proceedings. The trial court, specifically me, has the duty to raise the issue of competency where facts are brought to the court's attention which raise a bona fide doubt, that's in quotes, as the defendant's competence. That's specifically a quote from People v. Harris, 185 Mich. App 100. That is actually cited in the Camerad case. Mr. Ambrose cites the two primary cases. It's People v. Camerad, 307 Mich. App 98, and the federal case of Drope v. Missouri, 420 U.S. 162, a Supreme Court case. So essentially the question for the court is, did the court have facts in its attention that raise a bona fide doubt as to the defendant's competence? Essentially, the court is focusing on the morning, the 15th, I think it was December 15th of 2023. So the analysis, and also People v. Cameron says the test for such a bona fide doubt is whether a reasonable judge situated as the trial court judge should have experienced doubt with respect to competency to stand trial. Evidence of a defendant's irrational behavior, a defendant's demeanor, and a defendant's prior medical record relative to competence are all relevant in determining whether further inquiry in regard to competency is required. That is a cite from People v. Camerad, which also cites the Drope case. So the court begins its analysis in terms of what I, as a trial court, knew or understood, or at least had experienced regard to Ms. Vander Ark's competency or alleged incompetency, what her behavior was. This court, even prior to trial beginning, had reviewed Ms. Vander Ark's competency evaluation, which is referenced by Ms. Bloomquist. And the court also had an opportunity to review the preliminary hearing transcript. In normal circumstances, the trial court, my practice is not to review those things in case it's a bench trial, and that the court needs to remain impartial. However, at the stage prior to trial, as Ms. Bloomquist indicated, Mr. Johnson had filed a motion to quash the bind-over, or at least remand for preliminary examination, because of incompetency that had occurred, or allegedly had occurred, during the preliminary examination. The court's review of the preliminary hearing transcript indicated that at some point during the preliminary examination, Ms. Vander Ark had allegedly experienced some distress. I think it was described as maybe a panic attack, and that Mr. Johnson had asked for a brief recess to allow Ms. Vander Ark to compose herself. Judge Maria Lattice Hoops in the 6th-year district court was in a unique position at that point to observe the defendant and her behavior, and indicated that she, I think it was almost a quote, that she looks fine, and she proceeded forward. So another court sitting, presiding over a hearing, at the time that one of these alleged panic attacks occurred, observed the defendant's behavior, made a determination that she was competent to continue forward. I think it's also important to note the panic attack that occurred in district court occurred not randomly, but after her co-defendant, Paul Ferguson, took the stand, which is seems to be rather convenient. But again, the court also looks to the judgment of the district court, who had a chance to observe this panic attack and made a determination that they would move forward. The competency report gives no indication that Ms. Vander Ark was incompetent. Just for purposes of the record, the competency report was dated November 16th of 2022. The preliminary hearing actually occurred on January 4th of 2023, and that the competency evaluation indicates in several instances that she was competent. Specifically, there's this is page 3, a quote from the competency report that says, during the interview, Ms. Vander Ark was alert and oriented to place, person, and context. She demonstrated an ability to retain and mentally manipulate verbal information, to remember multiple items after several minutes, and displayed a sound reality testing and good judgment with regard to hypothetical situations. Ms. Vander Ark's memory was good with respect to ability to recall relevant details of her background, history, and activities around the time surrounding the alleged instant offense. Her cognitive abilities are estimated to be at least within average range, as evidenced by her education and performance with respect to above-listed capacities. This estimate is supported by her self-reported academic and employment history, as well as her conversation style, vocabulary, and ability to reason throughout this interview, end quote. Later on, there's a list in this report of her understanding of the nature and object of proceedings against her. I don't want to read the whole thing, but clearly she understands exactly what's going on, the understanding of the roles of courtroom personnel, her involvement, her in her defense, her counsel's responsibilities, the prosecutor's responsibilities. Ultimately, under the section labeled competency to stand trial opinion, the examiner indicates in quotes, I did not observe any behavior indicative of intellectual disability or other cognitive, psychological, psychiatric issues that would impede her adjudicative competence. It says, in my opinion, Ms. Vander Ark was aware of the charges against her, how they came about, and provided a consistent version of how events unfolded from her perspective. She considered her defense options as reasonable expectations and appeared legally knowledgeable. In my opinion, Ms. Vander Ark demonstrated sophisticated understanding of roles of various court participants, her defense options, and possible outcomes, and clearly voiced her willingness to engage and rationally assist in her attorney in this matter. In my opinion, Ms. Vander Ark was able to understand the nature and object of proceedings against her and to rationally assist in her defense. Therefore, in my opinion, she is competent to stand trial. Just because, obviously, I'm sure defense would argue that just because she's competent in one moment doesn't mean she doesn't become competent in another moment, but that's certainly something the court had reviewed prior to my interaction with Ms. Vander Ark up in circuit court. Then the court had a chance to observe Ms. Vander Ark at trial. Ms. Vander Ark appeared to be calm, collected. She interacted with her trial counsel, Mr. Johnson. She appeared to be writing notes, handing those notes. She interacted with Mr. Goings, her co-counsel, along with Mr. Johnson, and she at least appeared to be very involved in her defense. The court has presided over several trials, and Ms. Vander Ark appeared to be more involved than many defendants are. Typically, defendants say a few things and they kind of leave it up to their attorney. Ms. Vander Ark was practically appeared to be a co-counsel sitting at a table. The first indication of any distress on Ms. Vander Ark's part didn't occur at any part of the trial, even when her co-defendant, Mr. Ferguson, was testifying. During all the other witnesses that potentially testified, the first incident that could be considered a potentially an issue or concern for the court occurred during the last day of trial on the 14th. Mr. Roberts was cross-examining her, and and just to be clear for the record, the court has not only reviewed the trial transcript, the court actually rewatched the entire trial, because you do not get the same feeling for Ms. Vander Ark. You can't get it from the transcript because there's no indication of how she's acting when other witnesses are testifying. We have the fortunate ability to have cameras basically focused on the defense table, prosecution table, so the court was able to observe Ms. Vander Ark's demeanor throughout the trial. But specifically going back to December 14th, Mr. Roberts showed a picture of the deceased Timothy to Ms. Vander Ark, and she had this episode of vomit. That occurred at approximately 3:51 and 36 seconds on December 14th. Everything calmed down, even apparently after that, and we resumed testimony only 10 minutes later. So being confronted with, even if for argument, Ms. Vander Ark is completely innocent of these charges, to see her son in that manner certainly, brings out a vomiting issue, but she's just ready to go after 10 minutes. Completely fine. And then Mr. Roberts continues to cross-examine her until 4:48 and 11 seconds. Mr. Johnson then does redirect until 4:51, and Mr. Roberts again recrosses her until 4:52. And during that whole period of time, again, she appears to be calm, cool, collected. She doesn't appear to be crying, and appears fine, doesn't appear to be suffering for any mental distress. And then 8 minutes later, as the court is discussing jury questions with the attorneys in a sidebar, there's a mental distress 8 minutes after any questioning is concluded. So that was what the court had a chance to observe that date. The court didn't receive any information from the jail staff or counsel or anybody that she was suffering any distress. After that, the court broke for the day and then resumed in the morning on the 15th. At that point in time, the court was going to start at 9 a.m. And Mr. Johnson indicated to the court, I think it was in chambers with Mr. Roberts present, that they were having some issues with Ms. Vander Ark's ability to come to court. It's unfortunate that these things were not placed on the record, but not specifically remembering everything, but the impression for the court was that Ms. Vander Ark was suffering some mental distress, was upset, was crying, but it was never brought to the court's attention that she could be incompetent. Now, I did have a chance to review the transcript. Mr. Johnson refers to the competency of his client. And in the context of everything that's going on, the court finds it not to be an expression of competency to stand trial, but competency in terms of her mental health is such that she's in a upset state. There was no other indication that potentially Ms. Vander Ark was incompetent to stand trial. The court waited 2 hours. It was then discussed with the court that she was going to waive her right to appear in person. And the court obtained a written waiver from Ms. Vander Ark, indicating that she did not wish to appear. The argument being made at the time now is that Ms. Vander Ark, at least according to her affidavit that was attached to the brief filed by her counsel, was that she does not recall signing that. And, throughout the trial, Ms. Vander Ark claimed lapses of memory, but it was clear to this court that those lapses of memory were self-serving, and that her ability not to remember things occurred during periods that she could be either criminally culpable, or at least the things that she had said would hurt her defense. So her allegation now that she does not remember that is rather convenient that the one component that she does not remember when she was in the jail was signing a waiver to appear. Her affidavit indicates that she was aware of other things that morning, but she's not aware of that. So based on all that, what the court had an opportunity to observe, I will indicate this. Mr. Ambrose indicated that these facts are like Drope. The Drope case involved a report from a psychiatrist that was given to the court regarding the client's mental health status, and which raised a doubt that the psychiatrist had recommended that the defendant in that case undergo a mental health evaluation or competency evaluation. That we don't have that here. We don't have a psychiatrist that gave a report. Defense counsel didn't give a report to the court or say there's a concern, or we got a report from somebody indicating that she needs to be undergo a competency evaluation. We don't have that here. What we have is the court's observations. A lot of these panic attacks seem to occur in moments where there could be some critical or really prejudicial information that potentially is coming in at the time of trial or prelim. They don't seem to be random. They seem to be calculated. So the court, based on all those things the court had observed, the question for the court is whether the information for this court raise a bona fide doubt as to her competency, or that she should be undergo a competency evaluation. And the court says that my ruling is that a reasonable judge sitting as what I was looking at would not have a bona fide doubt. That it was, at least according to this court, was clear that she was competent. Now, was she suffering some distress? Yes. In most trials, cross-examination is very stressful. Mr. Robinson is a seasoned trial attorney. He engaged in very good cross-examination, very pointed. That is upsetting to most witnesses. And I have no doubt in my mind that Ms. Vander Ark was upset and potentially didn't want to come to court to face more of the cross-examination. But there's nothing that was before this court at that time that raised a bona fide doubt as to her competency to this court. Now, as to the issue of actual competency, whether or not she was competent, again, there's two standards. One, should the court have held a competency hearing? That's based on whether or not the court had a bona fide doubt as to her competency. So the court finds that it did not have a bona fide doubt as to her competency. The fact that the question is, was she competent? Again, there's the hearing, and then there's whether or not she was competent. Now, Mr. Ambrose, in chambers, we talked about potentially taking testimony as to Mr. Johnson's observations of Ms. Vander Ark, as well as any other caseworkers that met with her. This court finds that I have enough information in front of me to make a ruling today. However, I will reserve the opportunity for Mr. Ambrose to call witnesses, or the prosecution to call those witnesses. But I am going to make a ruling on that issue today without prejudice, so the court can hear additional testimony. Mr. Ambrose has requested that if that testimony occurs, that he would like his client here. I don't have an objection to that. Having previous history as a defense attorney, the advantages of having your client right next to you during cross-examination or during examination are incredibly important. So he said, if we're going to have testimony today, and I think his client has expressed that she would like to be here, I don't have any objection to that occurring, and so likely that will leave us in a position where we'll have to have a hearing at a later date where Ms. Vander Ark will be present. However, in terms of the court's finding of competency, Ms. Vander Ark attached an affidavit to the brief filed by her attorney. And I think a portion of that is very telling in terms of her competency. Specifically, I think it's page 11, last paragraph. She indicates, I testified for around 5 hours on the Thursday of trial, was supposed to finish my testimony on Friday, including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. However, I had a severe mental breakdown on Friday morning. I had several panic attacks and was completely paralyzed, unable to even make it to the elevator to go to court. I curled up into a ball and was barely able to communicate. During this time, I specifically asked Mr. Johnson to postpone the trial until I was able to participate. When I asked this, he said there was no point in delaying anything. He stated that they could continue without me. I never agreed to waive being in court for the rest of the trial. If there is a document with my signature on it, I do not recall signing it. Further, I was in no condition to agree to proceed without my presence. The standard for competency to stand trial is different than potentially just being unable to move or being unable to talk. What competency is essentially is, do you understand the object of the nature of the proceedings against you, and do you have the ability to assist in your defense in a rational manner? Ms. Vander Ark is indicating in this affidavit indicating that she knew there was trial going on that day. She also indicates she had very important questions that she wanted Mr. Johnson to ask. She understands that Mr. Johnson's his attorney, that he asks questions. She's apparently of enough sound mind to form important questions for him to ask. She also understands that, that she asked to delay the trial. So she's aware there's a trial going on. So, looking at those things, when you go to the competency element, again, it shows the court that she has an understanding of her attorney, the prosecutor, the trial, those things that are going on, but she wanted to proceed with her presence. The court is not held slave to somebody's being upset that they don't want to go to court. The test is competency to stand trial. Are you competent to stand trial? Not that, well, I'm crying and I'm just really panicked and I'm in, that's not the standard for the court. Now, the courts give a lot of discretion to allow a defendant time to calm down or witnesses to calm down to see if they can proceed. This court allowed Ms. Vander Ark 2 hours in the morning. And it was then made, and quite frankly, there was no threat to Mr. Johnson, or not much of a threat, but there was no indication that, well, Mr. Johnson, we got to get rolling right now. We got to go. It was Mr. Johnson, her counsel, that said she wants to waive her appearance here and wants to go forward with me representing. And based on the court's finding that she was competent at that time, her appearance, her lack of appearance was voluntary. She voluntarily did not want to appear, and that's evidenced by her written waiver. And again, she's saying, I don't remember that. Court finds that to be self-serving. She doesn't remember something that could hurt her defense legally. There's specifically People v. Swan 394, Mich. 451 indicates, quote, a defendant's voluntary absence from the courtroom after trial has begun waives his right to be present and does not preclude the trial judge from proceeding with the trial to conclusion. There is, at least in the court's estimation, there was a valid waiver signed by a competent, legally competent person. That was the court's, that's the defendant's voluntary absence. She chose not to be here. The court proceeded without her. Even in absence of a waiver, the test for determining whether a defendant's absence from a part of trial requires reversal of his or her conviction is whether there is any reasonable possibility of prejudice. So the other question is, even if Ms. Vander Ark had not waived her right to be there, and even if she potentially, I don't want to say incompetent, but the fact that she was not there, the court looks at the prejudice component. The trial was concluded. The only thing left was jury questions and closing argument, deliberations. That was it. And so based on that, the court finds the possibility of prejudice was minimal. The court explained the absence of the defendant to the jury, said that she was suffering from some medical distress. She wasn't an order for her not to appear. She didn't do anything wrong, essentially, but she was not going to be here. And so the court finds that there was no prejudice to her not being here. Now, the other interesting thing that the court last night reviewed the video again, there was this question of, well, there was questions that want to be posed to her. The the traditional examination stage is essentially direct examination, cross-examination, redirect, recross. That all had occurred, and it went back to redirect after Mr. Roberts had recrossed, and Mr. Johnson essentially said, "We're done with our questions." The only thing that was left was jury questions. Jury questions are in the discretion of the trial court. There is no right by a defendant to have a jury question or offer her questions. So essentially, the component that was, even if she is not here, the component that she gave up was presence for jury questions, which may or may not have been admissible, may or may not have even been able to have been asked her. And it's something that was not a right of the defendant to have a jury ask her questions. All the things that typically come into a trial occurred, and the defense was done asking her questions. So there is no guarantee at all that she would have been asked any more questions whatsoever. And she didn't have a right to have those questions posed to her, although it was the practice of the court. So all those things, the court is finding that she was competent. It does not warrant a new trial in this case. There was no bona fide doubt that she was not competent to stand trial the morning of. So with the reservation that I've already made in terms of additional testimony from Mr. Johnson or another caseworker which needs to be called, at this point in time, the court is making the ruling that the motion for a new trial based on incompetency is denied. In regards to the basis for relief off of ineffective assistance of counsel, Mr. Ambrose does raise some, I think, are legitimate issues regarding defense strategy. Both parties know that many of these decisions not to call witnesses or not to question about certain things or not to raise certain defenses are a matter of trial strategy. However, the court feels that that record needs to be developed more with Mr. Johnson, Ms. Vander Ark's trial counsel. In particular, of concern to the court is the allegation that Ms. Vander Ark did not authorize Mr. Johnson to essentially concede guilt to voluntary manslaughter. That is a pretty significant issue, which many times leads to reversal and a new trial if that actually can be proved to be true. I don't know that, but I think I think it's irresponsible of the court to simply make a decision on that based on just briefs without further developing that issue. So in regards to the motion for a new trial based on ineffective assistance of counsel, the court is going to grant the defense a Ginther hearing for those issues raised in the brief. That will not occur today. As I indicated, Mr. Ambrose would like his client here for questioning, and I think that is a reasonable request based on this motion. So the court will set that for a further evidentiary hearing at a later date. Mr. Ambrose, anything clarification from the court that you'd like, or any issues that you have for the court at this time?
Just one thing, and I put in my brief that I never did receive that waiver. And if I can just put the written waiver on the record of what was signed by my client.
Yeah, that's fine, that's fine.
It says, I, Shanda Vander Ark, defendant, agree to waive my right to be in the courtroom during the trial of Timothy Ferguson. I mean, and that's dated December 15th, 2023. So it seems somewhat, and I just received this today, because in my review of the court file. Now, if that has any impact, if the court wants to evaluate that, maybe my client didn't. She's obviously, her record, her past, her history, she's pretty much on top of things. Doesn't
Well, like I said, I made my ruling. It doesn't change my ruling, Mr. Ambrose, but I appreciate that, bringing that to the court's attention. So, I also want to make it clear for the record, the waiver was in the court file. Unfortunately, it was misscanned in circuit court. It was actually attached to the jury verdict. So when the court received the motion, I looked for it too, and I could not find it. And eventually my staff realized that it was actually scanned inadvertently on the there's a second page of the jury verdict, which it should have been separated out. So I think it should have been provided to you as part of the court file, Mr. Ambrose, if you received the jury verdict. But I don't know. Like I said, it may or may not have been in the material, but if you asked for the record, it should have been in there because it was a digital copy, but I won't hold you to it. Anyway, Ms. Bloomquist?
Nothing further from the people, Your Honor.
All right, so the court will schedule this for a Ginther hearing at a later date. Thank you both, well-written briefs, good arguments, and we'll see you at a later date. So we're
Thank you.
adjourned.